This conference will now be recorded.
Welcome, everyone. I'm very excited for the session that we have tonight because it's a very, very complex and desperately needed to be discussed topic. With us tonight, we have Mr. Michael Leiner and Ms. Jennifer Morgan, who are both lawyers in disability, and they are going to talk a little bit about why they've gotten involved in all of this. And I'm going to do a quick disclaimer that this Q&A session is not going to be talking about clinical stuff with Chiari, Syringomyelia, and different chronic pain situations. It's going to be really more about how you're funding treatment, essentially, with Social Security, disability benefits, because it's a very difficult to navigate world. But I think with that, I'm actually going to get started and just have you both introduce yourselves, maybe why you've gotten involved in disability law and chronic illness and stuff like that. And with that, I'm going to kind of go away and have you guys start however you prefer.
Go away. Just fade into the background.
Thank you, Caitlin.
Yeah.
I'll go ahead and start, Michael, if that's okay. Thank you so much for having us. We are really, really excited and really honored to be here. And we want to serve you through this presentation. That is our main goal. So however we can meet your needs, please just let us know. So we have prepared this information because we believe it's what is most helpful. However, if you have specific questions that you feel comfortable asking in a group forum, please feel free to use the chat box. And if you don't, then we have our emails and phone numbers at the end of the presentation. We're happy to sort out things with you afterwards. With that being said, I founded Impact Disability Law in Denver, Colorado in 2017. I have been a lawyer actually since 2007, but have mainly worked in the education sector. My first career was actually working as a kindergarten teacher, and so I take on a lot of kids cases in addition to my adult cases, which is a whole nother ball of wax, I guess. I don't know. But I'm really passionate about both the children's and adult cases and absolutely love what I do. When I was doing mostly education law, I was working in the special education realm, and so that kind of led me into this type of law and have been passionate about this ever since. That little guy is Hudson. That is mine. He is 9 now. This was actually taken in 2nd grade, so that maybe it was 1st grade. That might be a 2-year-old picture. He's fully toothed now and very tall. So anyway, that is a little bit about me. Michael, I'm going to turn it over to you.
Thanks, Jen. Yes, my name is Michael Leiner, and I started my law firm, Leiner Legal, which is based in Cleveland, Ohio. We have offices throughout Ohio back in 2013. A little bit about me, I came to practice disability law because it's sort of been my own journey, is navigating life with some different health challenges. I'm very fortunate that with medication and treatment and parents who never gave up when it would have been very easy for them to do so, I have been able to, move forward with life and have a successful career. But I live with cluster headaches, motor tic syndrome. I had epilepsy as a child, and it was, as is, I'm learning is more common. I actually found out, when doing an MRI of the brain for cluster headaches, that I have asymptomatic Chiari. So it's something that, as many people who see that in interpretation on a study, they panic, they're concerned. I've been there myself, but I certainly come to this practice knowing what it's like to deal with health challenges, which has really just allowed me to, I think, develop a deeper connection with my clients and the people that Jen and I present to. Elevate Disability, that's what this is. This is not our private law firms. Jen and I don't work together, you know, during the daytime. This is our passion project. This is her and I. We started Elevate Disability because there is so much misinformation out there about disability benefits, and especially for people who have, you know, what I would call more rare disorders, like Chiari, or, you know, other conditions. There's just not a lot of good information, and we think it's important to, especially now that we can do so many things over Zoom and go-to meetings, we want to, you know, as experts who do work in this field day in and day out, share what we can and not just, you know, have people turn to the internet where there's so much bad information out there. So like Jen said, feel free to contact us afterwards if you have additional questions. And down at the bottom of the page there, you can see my two kids who, yes, they've gotten a little bit older since those pictures were taken as well. My daughter Eliana is 6, and my son Dylan is a very precocious 4. So let me move forward, and this is just going to kind of give you a little bit of a preview of what we're going to talk about today. And here's the things that I hope you guys leave this presentation with an understanding of. First of all, what is the definition of Social Security disability? Because I think that it will help you get a grasp on what you have to prove in order to receive these benefits. We're going to talk about what the different types of benefits are. Many of you submitted questions before our presentation to Mary or just the organization, and several of the questions that I reviewed had to do with what different types of benefits were available. So we're definitely going to be covering that today. We're going to talk about what the disability process is like, because it's not an application process where people quickly get approved in many circumstances. And then we're going to talk about why that is, and what it's like to be a disability applicant who has you know, Chiari or Syringomyelia, and then this is where I get most excited. We're going to talk about what I think the keys to a successful disability claim are, and just to kind of preview a little bit, Jen and I have a very conversational approach when we present. It's not she takes a slide and I take a slide back and forth like that. We're very just conversational. So you guys can just kind of follow along as you have questions. Like we said, please submit them and we'll do our best to answer everything that we can before the end of the evening. But we really want to make sure that you walk away here with the best understanding from our experience. You know, between us, we've probably handled you know, over 5,000 disability cases at least. And from that experience, there's a lot of tips that we can give on what you should do and what you shouldn't do to give you the best chance of being approved for these benefits. And then the last thing, you know, a lot of people have questions about why to hire a disability attorney, so we'll talk about that, okay? So the first thing that's on here.
Yeah, I think it's really important. And Michael, I just want to touch on this because disability as a generic word has a lot of different meanings. And the definition under Social Security is very specific. And so I think the 3 things that we really want to touch on here is that you cannot be earning over SGA. You have to have a medically determinable physical or mental impairment. You can have both, and it's got to last 12 months. So this is kind of a 3-pronged definition. So the point of this slide is to really show you, here's the legalese definition of this, but you really have to meet that 3-prong the 3 prongs to be eligible. So Michael, will you talk just a little bit about SGA, what that means, and pretty generically just what would kick somebody out of eligibility if they were earning over SGA?
Yeah, so just roughly what SGA is. Substantial gainful activity, to put it all together, is somebody who is working for pay or profit and earning this year in 2021, but it goes up every year. But in 2021, it's somebody who is working and earning more than $1,310 per month. That's for a non-blind individual, okay? Non-statutory blind individual.
Is that evaluated monthly, Michael, or is it something that will be looked at over the course of a year? If someone's like bumping up right to that, like talk about the nuances of if you're right there.
Great question. It's a monthly amount. And why it's so important that people understand that it's a monthly amount is because Social Security does have different things like trial work periods and extended periods of eligibility. And what they're looking at for each of those different things like trial work periods, extended periods of eligibility, whether somebody engaged in an unsuccessful work attempt, is their monthly earnings. So they won't look at if somebody earned $4,000 in one month and then they only earned $200 in the next month, they're not going to average those two and credit them as SGA for the 2 months. They're only going to have engaged in SGA in the 1 month that they earned that $4,000. That's really important, especially when people are higher earning individuals. But SGA essentially is somebody who is working for profit, earning over $1,310 a month. And if you are working and earning more than that, you cannot receive disability. And that's very important because there's so many misconceptions out there about, when somebody, whether or not, to get disability, I just need to limit my hours. I need to go down to part-time as long as I don't work more than, I've heard people say more than 20 hours per week, or I just can't work more than 25 hours per week, then it's okay. No, it's an amount of money. And again, because it doesn't matter how many hours you work. If you worked 2 hours that entire month, but you earned $2,000 because, you are a very successful doctor who earns $1,000 per hour, you are engaging in substantial gainful activity and you're not eligible to receive those disability benefits. Unless you have there's things called impairment related work expenses that can allow you to subtract for a little bit, but those are exceptions that would be just far too complicated for us to get into today. Generally speaking, no matter what the circumstances are, if somebody is working and earning over $1,310 a month in 2021, you cannot receive disability benefits. Okay?
Yeah, and I think this question comes up a lot for me when I have clients that are still working and they know that they are limited. Okay, they know that they they can see that they're really decreasing their hours, their limitations are increasing, and they're like, when should I apply? It's a very individualized conversation. I think that goes to the very third prong of this definition, where your physical and mental impairments must be expected to last over a year, over a 12-month period or longer, or result in death. And so if the diagnosis or the symptoms around that diagnosis as a whole person taken all together, they're going to limit you. Disability is not a fast process. You don't apply and get approved in 2 months. It can take 2 to 3 years. So I think the reason why we like to bring this definition up is because even if you're on that edge of SGA, but it looks like things are decreasing steadily each month with your abilities to work, there is some careful planning and consideration that can go into when it is appropriate to file your initial application. If you file and you are earning over SGA, you'll typically be kicked out on a technical denial. But let's see. Looks like we have a question here. What if you're getting an inheritance from deceased parents and that amount is over SGA? That is a great question. Thanks, Corey, for asking that. Michael, I'm going to turn it over to you. You love this question.
I love this question. Now, remember what I said. It's the $1,310 is money that you earned by engaging, from work.
Yeah.
An inheritance is not something from, work activity. So you can have a $10 million inheritance. You didn't work for it. So for Social Security disability insurance, and we're going to talk about another disability benefit that's called supplemental security income that has rules that are a little bit different, but that's not SGA. So that inheritance is not going to impact whether or not you can receive these benefits.
Yeah, good, thank you. And I think I just want to touch on one thing because I want to get more to the meat of our presentation. We can belabor this definition all the time because we're nerdy and love this, but that's really not the super point. It's just a great foundation to have. But the medically determinable physical or mental impairments, the question I get around this a lot is, okay, I've already filed, I didn't put this diagnosis or this symptom or this ailment or this impairment or this challenge that I'm having on my application. Can the judge still consider this? Can disability still consider this? And what Social Security is looking at is your body as a whole, your mind, your body, everything. So if something comes up after the fact and it's preventing you from working, it is something that can be considered. So it's going to be any, I think, Michael, you've said like throw in the kitchen sink when you're applying, like make sure anything that is causing you issues should be listed on your application.
Yeah.
Let's go ahead and let's move on. I think we belabored this slide. We'll touch on the other things later. Okay, so Michael touched on this before. We've got the two programs. There's the other programs, but these are the main two that people are eligible for. Okay, so we've got Ssdi on the first column and SSI on the second column. We have sorted out, there's other nuances, but these are the main nuances, okay? So you'll see for a work history, for SSI, none is required. So it's based on your limited income and resources. That's where an inheritance could actually kick you out of eligibility. So if you have not worked, you don't have 20 quarters of coverage, and you're applying for Ssdi, then the inheritance issue is not going to come in. However, if you've got SSI on there, that could impact that. And it's kind of a nuanced conversation that we could go over with more information. Michael, do you want to talk about the difference with the health insurance?
Yeah, so Ssdi, if somebody is awarded disability benefits, comes with Medicare, which is the health insurance that comes along with retirement benefits usually. It also attaches with disability benefits, whereas SSI comes with Medicaid, which is usually administered by the local or state government. I want to go back a little bit and talk about what, I just to make sure that we're clear, everybody's clear on the differences between these two benefits, and more so talk about what the difference between Ssdi and SSI is not, even though I think it's clear on this slide, because people say things to me all the time and I want to dispel common myths here. Okay, people will say things like, I want the short-term benefit. I don't need the long-term disability benefit. I'm only going to be out of work for a few months. And I always think that they think that maybe SSD is a long-term benefit and SSI is a short-term benefit. The medical standard is the exact same no matter which benefit you're applying for. Whether it's SSD or SSI, the medical standard is the exact same. I will hear people say things like, I need the benefit for the people who have physical health challenges, not the mental health one, the physical one. the medical standard is the exact same. The rules as far as what you have to prove using your medical records are the exact same regardless of whether you're applying for SSD or SSI. The difference between these two benefits comes down to SSD is for people who have worked and paid into Social Security. Notice the "and" there. And paid into Social Security. And SSI is essentially a federal welfare benefit for people who are disabled. You don't have to have ever worked at all, okay? Generally speaking, you have to have paid into Social Security for 5 of the past 10 years, which breaks down to being 20 quarters of the past 40 quarters. It's a little bit less if you're under age 32 because you wouldn't have had an opportunity to have worked that much. There's another benefit that falls, and I'm stepping outside the slide here because I want to address one of the questions that came in before we presented today. Somebody had a question about a child of theirs who is, I think, college age, maybe 26. They were unable to complete college and never had a chance to work. So they wanted to know what benefits were available, okay? So SSI, first of all, but there's another benefit that we don't go into on this slide, but it falls under the SSD bracket, which is called adult child benefits, okay? And what that benefit is it allows somebody who, if they became disabled before the age of 22, that's very important. You have to become disabled before the age of 22 to receive disability benefits on their parent's work record. Once the parent is either drawing disability themselves, receiving retirement benefits themselves, or becomes deceased, okay? And that can be either parent. So the child can draw benefits on the parent's record. When that's really important is, because the disability amount for SSI, it's capped. You see this at the bottom here. We talk about the monthly benefit at the bottom here. The most that somebody can get in SSI benefits per month, some states bring it up a little bit with a supplement, like California, I think, adds another $200 a month or so. But generally, most states, the most that somebody can get receiving SSI is $783 a month this year. It goes up slightly every year, okay? With SSD benefits, people can get up to about $3,000 per month if they had a strong and long work history. It's based on the amount of taxes that you paid in, which if you were a 6-figure, wage earner who paid in for 30 years, you're going to be able to essentially draw out what you would receive in retirement benefits early if you can't work anymore, okay? But SSI, because it's a needs-based benefit, it's very, very small. But to avoid totally penalizing somebody who just never had an opportunity to work because they became disabled so young, they can draw on their parents' work record in those very limited circumstances, okay? Now, there's some circumstances that can cut off those benefits that they need to be wary of. And I still want to make sure I'm answering the question for the person who asked it. If your child gets married, that would make them ineligible for adult child benefits. If they ever do work and earn SGA, which we belabored what SGA was, but now you know, and know how important it is. If they ever do earn SGA, then that would make them ineligible for adult child benefits, okay?
Okay, Michael, we have a nuanced question. So it says, for these adult benefits, do you have to be disabled before 22, or do you have to have proved that you were disabled before 22?
I love this. Nothing with, and because I'm about to say one of my I'm full of disability one-liners. That's why Jen is smiling so much. Okay. And one of my favorite one-liners is, winning a disability case is not about what's actually wrong with you. It's about what we can prove is wrong with you. Okay. You can be disabled, but if I can't prove it, you're not.
Under Social Security.
Yes. So,
right.
You must be able to prove that you were disabled before the age of 22. And you can use all kinds of evidence, but really to get Social Security to agree, they're going to want to see medical records or education records if it's a case where maybe there's some special education records that would help prove that. Or some type of vocational rehabilitation records if those existed. But you know, a letter from your friend that says, I knew him when he was 21 and he seemed a little off, but you're 45 now. I can't see many Social Security adjudicators or judges jumping at the opportunity to write a check. It's about what you can prove through good evidence existed before the age of 22 in that instance. But with everything we're going to talk about, it's about what you can prove is wrong, not what's actually wrong. That's how you win the case. So thank you for giving me the opportunity to say that.
More to come with you. All right, let's move on to the next slide.
Before though we didn't mean to go, oh wow, what happened here? I think that some of our slides got cut off, Jen.
Okay, go back to
yeah, that's okay.
Table of contents.
That's
and,
okay. Here's what we'll do, and we'll I don't know why something got deleted, but we'll send out to because I know everybody had to give an email address to register for this, so we'll send the slides that I must have accidentally hit the delete button on.
Is there a way, Michael, that if I can talk about some of the evidence that you were just talking about, that you could add those slides in? Do you have a second? If I can talk about the medical evidence.
How about you do that and then switch the share screen with somebody else, and then I'll just quickly add it back in. Take me 1 second.
Okay. Maybe Caitlin can help out with that.
There we go. All right.
Perfect. Okay, great. So Michael was talking about strong medical evidence, and the one thing that we really love to impress upon our clients is, how do you speak to your medical providers in a manner that helps a disability case? I am not a big fan of telling my clients to go in and say, I'm applying for disability, so please make sure you write this into your medical file. I also understand that when my clients go to the doctor, it feels like they've got about 5 to 10 minutes with their provider, and it's really hard for them to get all of the information in that they need. And so one tip that I like to give my clients is, when you go to your doctor, number one, you are not talking just about how you feel that day. You might be having a really good day. I would like you to talk about how you have felt overall since the last time you were at that doctor. So say that you see your specialist every 3 months, or your PCP every month, or vice versa. I like to have my clients keep either a notebook or notes in their phone, whatever they're most comfortable with. But specific examples of where they feel they are limited. One example might be, I am struggling to wake up in the morning, and out of the last 20 mornings, 17 of them, these are my symptoms and this is what's happened. Or here is the pain that I'm feeling, and this is how this is limiting my ability to sit for a long period of time. So it's really being able to give specific examples of functional limitations. I am stealing one of Michael's favorite one-liners, but when you are proving a disability case, you are answering, it is a vocational question with medical evidence. So sometimes they go this way and they don't necessarily line up. But my job when I am in a hearing is to pull those functional limitations out of my client's medical records and say, do you see this example of where they had a hard time, with their grip strength this day, or they had a hard time walking for a certain period of time? I am constantly trying to extract that information. And so for a mental health case, I have anxiety and I have a hard time taking public transportation. This is in the pre-COVID world. Certain things that would indicate this is going to prevent my client from working 40 hours a week, 8 hours a day. I want to pause because Caitlin has a question. So she said, are there certain exams that are good to have more routinely in maybe a primary care setting that can help provide a baseline of evidence for a disability application? Caitlin, I love this question. Yes, and as the famous lawyer answer, it definitely depends on what the client is struggling with, what their challenges are. There are two things. Social Security might actually send you out for a consultative examination. That's a physical or a mental examination. And so that might happen in the midst of your Social Security case, which we'll talk about when we get to the disability process. I know that both Michael and my office, we use functional capacity forms. So we've got functional capacity forms that are actually specific questions directed to your doctor that kind of key into whatever disability that you're struggling with. And so the doctor can actually take their information based on their knowledge of seeing you and fill in those questions. And it talks about how long can you stand for? How much can you lift and carry? You know, what could you do? I mean, there's very specific ones, different nuanced things. In terms of exams, objective evidence is always going to be viewed by the judge. So for whatever reason, it's just easier than subjective evidence. It's easy to see a number on a page. So any objective tests are always going to be something that a judge keys in on. And so obviously, if those are more favorable examinations, then it's going to be almost imperative to have those. Although sometimes, you know, in terms of pain and subjective pain, I'll have clients that'll have an MRI or that'll have, you know, an X-ray that shows objectively they should be fine, but their pain doesn't align with that and doesn't match up with that. And so that's really why it's important that they're able to express, like, look, I understand that this is what's objectively saying, but my pain is X, Y, Z, and here are examples of when I'm experiencing that pain. So it's very important that you go in kind of clear-minded to talk to the doctor, which is hard because I feel like I was just at the doctor yesterday for a routine physical, and I was kind of noticing I'm just rushed through this. And I had a list of things, and she was even like, I'm going to stop you. I can't talk to you about X, Y, Z. You're going to have to make a telehealth appointment. And I thought, oh my gosh, my clients, you know, I even have my list, and I'm like, my clients can't get all of their information. There's no way into the doctor this quickly. So I'm going to stop. It looks like, Michael, you've solved our problem.
I have solved our problem. I also want to chime in with
Okay.
something that I think is so important because, you know, you're talking about a problem that everybody on this webinar has experienced, which is your doctor probably has 15, 20 minutes to see you in many circumstances. If you're seeing a quality specialist, maybe you've got half an hour, 45 minutes. But
right.
How do you fit 6 months? I mean, if you're seeing a specialist, you're also not seeing them monthly. You're probably
Right.
only every 3 to 6 months, and there could be so much information you have to relate. So how do you give them all of that information that's important to you? And one thing that I think, you know, COVID has really expanded for us is the prevalence of things like electronic health records.
Mhm.
People are messaging their doctors more, depending on what health system you have. You know, a lot of, you know, I know that the doctors that I see, you know, I can message them through my smartphone if I'm having any issues. And that's a habit that everybody should get in because, you know, Jen, when you went to the doctor yesterday, there were probably 9 things that you wanted to say, but you didn't get a chance to say. But now, you know, if you went back and I'm just using you as an example, but if you went back and you sent a message with the 9 things you didn't get to say, at least you know that they're documented in your record.
That's
And
true.
I'm going back to what I said before. Winning a case is not about what's actually wrong. It's about what you can prove is wrong. But if you didn't get to say those 9 things, if the doctor didn't get a chance to address those things, then your records are deficient.
Mhm.
And winning a disability case is going to be about the medical evidence. It's not going to be about the forms that you fill out. And that now I can kind of transition back to the slides that we added in. But use the technology that's available to us now to your benefit. And there we go. I want to, before Jen and I go through what's on this slide, I want to talk a little bit about a few things. First of all, why is it so challenging to get disability if you have Chiari or if you have related conditions? And to talk about it, there's several reasons that I want to put out there. Okay, first of all, they're misunderstood, and they're not well known by judges. They're not even well understood by the medical community. I'm sure, if I can't see your faces, but if I were to be able to see everybody's faces on here, I would see a lot of heads going up and down. It can often take years to receive the right diagnosis for something. So imagine that you're an administrative law judge who sees, 8 claimants a day, and somebody comes in with a rare disorder or something that's not run of the mill, but you've got 8 cases the next day too, and 8 cases the day after that. Are you going to have time to go and do a bunch of research to really understand what's going on with that condition, or the adjudicators at the earlier level of a case? It just doesn't happen. And so one of the reasons that it can be more complicated to get disability if you have a more rare disorder is the same reason that it's so challenging to get a diagnosis in the first place. It's just not as understood by the legal community. It's not even understood by the medical community. And so part of what's important is, for that Jen and I take the time to do, is to educate. And I don't mean talking to you. I mean talking to a judge. I mean setting up the medical records and the symptoms and functional limitations in there and linking them back to all the physical findings that are in the record, so that, a judge who, might just be flipping through cases all day can say, wait a minute, judge, I need you to understand why there's weakness in that upper extremities, why these headaches aren't just the, take a Tylenol and take a 20-minute nap and go back to what you were doing before headache, why the numbness and tingling in the feet are not going to be controlled necessarily, just with some medication. This is more complicated than that. But if somebody doesn't raise their hands and go like this, it's just not going to happen. It's just next case, next case, next case. So that's why. The other reason is because Social Security has a book. It's now online. I haven't seen the book in a long time, but it's called The Blue Book of Listed Impairments. And what it does, it's divided into chapters, and it lists out every bump, bruise, and ailment that you would imagine could be wrong with somebody. It's got a chapter for mental health, a chapter for cardiovascular health and impairments. And then within the chapters, it lists out individual diagnoses. And it says, for this impairment like epilepsy, here's specifically what we're going to look for. And if you meet these specific criteria, we're going to find you disabled. There is no listing for Chiari. There is no listing for Syringomyelia. Okay. And because of that, they have to move on to treating it like, okay, so what are the symptoms and functional limitations, which are misunderstood? It just looks like every other case to the judge who's seeing 8 a day.
And not measured by objective studies also. Yes. So then we're going off of subjective medical evidence, which is really based on what you're able to communicate to your provider, and what your provider is willing to write down in the medical record also.
And so how do you overcome that? Now we're going to talk about what's right in front of us here. How do you overcome the fact that these things are misunderstood? Okay.
And one of the things when I talk to a client who is struggling with, because a lot of the time when I have a client who comes with kind of a more rare diagnosis or a more rare condition or something that's misunderstood, you know, they will say to me, they know that this is a big burden to prove. They understand the difficulty. They've done research. And so one question I asked, and it goes to the first bullet, is, so tell me about your relationship with your doctor. And typically I get, you know, someone who talks about how they've visited several different doctors to find one that either A, will listen, B, that knows, that understands. And you know, I'm like, kudos and hats off to you. I know that that is an exhausting and a long process, but having, you know, that positive, just that somebody is going to listen and really just try to figure out what's going on and how to help you. And Lindsay has a question: does your physician have to agree or sign off for you to file for disability? Some doctors act like you're fine and there's nothing you can do, but it's hard living with these conditions along with the other conditions they cause. That's a great question, Lindsay. No, your physician does not have to agree or sign off for you to file for disability.
Common misconception. Yeah.
What?
A common misconception is that a doctor does need to.
Right. However, the reason we put number one, or the top bullet on this slide, is when we see that doctors are supportive, we can get better medical evidence, which ultimately then overcomes the hurdles that we just spoke about. Yeah. And so it's not the end of the world if you don't have a doctor who isn't a positive situation, but we just feel like, you know, and I do want to caveat this because I feel like we got ahead of ourselves, and I'm sorry. Obviously, when you're communicating with your provider, you're there because you need the treatment. We're not saying that we want you to fabricate or in any way not be honest about what's happening so that you can get disability. That's not at all. What we're saying is we're trying to teach you the language that Social Security speaks, that they hear, that they listen to, that they see. And what that is the functional limitations that your impairments are causing. And that is a lot of times missed in medical records, especially when you don't have that supportive kind of medical provider relationship. And so obviously when you're going in the normal course of treatment, and you're trying to figure out what's going on, or you've got these conditions, don't give up. Keep communicating what you're struggling with. Keep talking about numbness in your hands. Keep talking about the nuances. Give specific examples, like when I go to try to open a jar, when I go to try to carry my coffee to the table, something happens. I mean, keep just thinking about things in the day that are really, really impacting your life. And that kind of goes into that communicating daily limitations to your provider. I think we've covered those first two bullet points, Michael. So I want to go ahead and move on unless you have something else.
The only other thing that I want to add,
okay,
that, and I think you've said this, treat to get better, because the same way that people get better is the way that you would win a case. Mm-hmm. It's by going into the doctor and telling them everything. Mm-hmm. And, you know, I think you covered it. You know, it's not about going in. I don't want you to show up to your doctor's appointment to say, hey, I'm applying for disability, so I need you to write this down. Go in and say, doctor, I'm having a lot of problems and we need to figure out how to fix them because I want to live my life again. Right, exactly. People become doctors because they want to help that patient. But as soon as you start talking like that, they used to take out their pen. Now they're going to start typing at that computer in front of them all the things that you tell them. And those symptoms and functional limitations are likely going to be in the record. And they're going to decide what test they need to order and what medication they need to switch around. And that's the evidence that Jen and I need. Yes. And I want to pause because we have a really good question. It's, what if you have a chronic illness and one possible treatment is a drug with potential significant side effects such as death? If you don't want to take
such a drug due to such a risk, would a judge look at your medical record and say that you refused such treatment and they would deny you benefits? I love these questions. You guys are very, very like smart, and these are fun ones to talk about. Okay, Michael, I want to hear your answer first, and then I can.
I want to be very careful about how I answer this.
Okay.
Because every medication that pretty much every medication is going to have listed as a potential side effect, death. If you go to a Tylenol bottle, because they are nervous about being sued because somebody took too many Tylenol once or many times, it'll list that a potential side effect is death. And that's I don't want to, sound like I'm being overly dramatic, and it's with all due respect to the question. Okay. However, here's what I think is a better way to maybe answer this question. A very common treatment for all of the conditions that we're here, that people on this webinar are living with, or your loved one is. Surgery is a very common treatment option. Okay, maybe the best treatment option. Okay, whether it's to create a little more space, to help with the syrinx, or whatever the case may be, to help fix the Chiari. There is within the law an exception that if you are a brain surgery is not required, and they cannot hold you refusing a brain surgery against you to deny benefits. However, with medications, it would really have to be a very dangerous medication, and I can't think of many that I've ever seen prescribed where death was such a risk that it would be okay to not take a recommended medication because of the risk of death. Surgery on the brain or spinal cord itself, you might be able, that would not be held against somebody. I hope that answers the question. If it doesn't, please feel free to ask a follow-up if you want to give a
anti-cancer drug is what was specifically referenced.
An anti-cancer drug? Have they already tried other forms of anti-cancer drugs?
I mean, for when you don't have cancer,
when you don't have cancer, it would really just, here's what I would want. I would, in this specific circumstance, want a letter written from the doctor that says, this is a real risk. And so even though this is an option, there is a quantifiable risk here of this person dying if they were to take this course of treatment. Yeah. Because I think many judges would struggle to understand that.
I do too. I think you are running the risk of a judge. I mean, we can give like a very, very more. I have, this is just for like an example, but I have clients who will say they don't want to do injections because they either had a bad reaction to one, or they don't feel comfortable with, I think one woman had an epidural when she was in labor 25 years ago. And so she was like, I do not want to go through that. I did not like the side effects of that. And that particular judge listened and said, I understand why you would not want to do that. I understand why you have hesitation for that, and was very empathetic. So I do think this is going to be judge specific. But if my client had that type of treatment offered, I think that I would get a letter from the doctor stating, exactly what Michael said, why, what the risks are associated. And then that was something that if it came up could be explained. So I think it's a really good question. It's really something to think about. But I think it's going to be, unfortunately, very judge specific once you get to that point. But I do think that there's going to be creative ways to kind of combat that if you believe that it's a concern. I would want to look at the medical record as a whole too, to see what else is in there, just to, you know, kind of figure that out. But that's a great question.
So many questions are going to end with an answer like, it depends on who's reviewing
And
the
I
case.
hate that. I do hate that. I'm sorry. We're trying to give you like some specifics, but I hope that what we're doing is teaching you the way that Social Security thinks about cases, so that you can kind of apply this information to your own situation or your family member's situation.
Yeah.
Okay, we gotta, Michael, I actually don't know our time limit on this.
So we've, just to cut in, we've gone over a lot, so don't feel overly stressed about the time.
Okay.
We can
Thank
add.
you. I've been like, where, gotta go, Michael, gotta go. Okay.
We've gone over the time allotted by a lot.
No. In the past, we've gone over by the hour, like, so pretty much every time. So don't feel bad about this. We're on. This is really great stuff. So I think
the next thing that's on here talks about the importance of conscientious form filling. So when you apply for disability, the first thing that happens is Social Security is going to start sending you some forms to fill out. They're going to send out a form that's called an Activities of Daily Living report. It's alternatively called a function report. They're going to send you a work history report. And a lot of people will very sloppily complete these forms, not really take the time to answer the questions that are asked. Here's the messaging that I think is important for people to know about these forms, okay? People do not get approved for disability because of how they fill out those forms. These forms usually are used to deny people, okay? So you're not going to convince Social Security to approve your case because of what you tell them is wrong with you. People get approved for records because of what we already said before, what your medical records say. So what you need to avoid doing is giving them on these forms that they send reasons to deny you by, rushing through them. When it asks you, if you have any issues with self-care, things like shaving yourself, toileting, really think about the question. If you have, numbness and tingling in your hands and arms, I would expect that there are times when it is challenging for you to shave. Maybe not every day, but sometimes. Really
Michael,
think about.
Let me ask you this. Let me give another specific example in the forms, because it's hard to talk about them in, generics, but there's a form that asks what can you do around the house, or what are your hobbies? And I have a judge all of the time go and say, oh, I see here in your form, which was probably filled out a year and a half prior to the hearing actually being conducted. So what can happen in a year and a half in terms of declined health is significant. But I see here that you like to garden, or that you like to ride your bike, or that you like to cook, or that you like to do X, Y, Z. That's the type of thing we're talking about. And so what would you recommend if somebody does like to garden, but they can do it sporadically, they can do it at best, that is a hobby, it's not a lie, that is, but would you leave it off the form? Would you, how would you approach that? Would you just not answer it? I mean, because I feel like I would be inclined to leave it blank.
I don't see why Social Security needs to know that you like to garden. What is the relevance of that to your case? It's not.
So what would you say as a hobby, or your hobby, or your activities that you like to do? What would you answer that question?
If I were to leave anything blank on the form, it would probably be that one.
Okay.
It'd probably be that question. Because
we've seen so many times denials happen because people can quote unquote garden or ride their bike or do things. Well, gardening in your mind might mean that you're out there once a month, or that you hope that you garden when you feel better, or whatever.
Why is it Social Security's business what you do in your free time? Or at least why do you have to be the one that's raising your hand and saying, oh, I like to do this activity or that activity? Don't do anything to hurt your case.
Right.
If you're going to give them information that's going to explain why you can't work. For example, on those forms, it'll ask if you do meal preparation. Don't lie. if you do meal preparation, say, yes, I do meal preparation. However, I have a chair that I put right next to the stove. Or, meal preparation, yeah, I prepare meals. It's frozen dinners and oatmeal and bowls of cereal every night because I can't, do anything that takes longer than 5 minutes. That's too complicated for me.
What if there was an answer, Michael, that was, because then I'm just thinking someone just said, not gonna lie, my symptoms flare after mowing my lawn. But what if there was an answer that said, I'm very limited in these types of activities that I've previously been able to do because of XYZ symptoms?
When you say something to Social Security, I got distracted when you said that. I'll be honest, Jen, because when you read that, when all Social Security is going to see is mowing the lawn.
Mowing the lawn. You can mow your lawn.
They didn't hear anything else on there. They didn't hear symptoms flare. They just saw mowing the lawn.
Yeah.
They'll get distracted just like I did. So why do they need to know that you mow the lawn? How is that going to help?
Yeah.
And I'm not trying to hide things from them, but why do you need to, be a self-reporting police officer? It's no business of theirs. I believe that if you are on this webinar watching this right now, especially like an audience like this, if you're applying for disability, you're disabled.
Mm-hmm.
I believe that. Okay. So my viewpoint is don't give them anything extra. Now here's a big tip. People try and say way too much on these forms. I have clients, and it's typically my most educated clients, that will send in to me like novels, and it's like they turn into Tom Clancy or James Patterson sitting down writing 300 pages, single spaced and 8-point font for me about why they can't work. If you can do that, Social Security is going to assume you could probably be a Walmart greeter or be a job that they have that's called an addresser, okay, where you just sit addressing envelopes all day. I don't even really believe that job exists, but Social Security claims it does, and that there's 100,000 people in the country doing it. Okay.
Yeah.
So give them as little as you can. You don't need to, you're not going to convince them by what you say that you're disabled. You need to tell your doctor what's wrong with you. That's where you make your case. So I think that that's probably a good bit on the forms. Okay.
Yeah, I think so too.
Deadlines, you just got, when you get denied, and I'll talk a little bit about the disability process here because we would, I think we've made it clear, and I'm sorry if we come off like pessimists, but the reason that there's lawyers doing disability work is because people who should be receiving these benefits aren't. This is a system of denials and appeals. That's why Jen and I have devoted our entire careers to this, okay? Of the people who apply for benefits at the initial level of adjudication, only at the initial application, nationally, only about 25% people get approved right away. Most states have a second level that's called reconsideration. Only about 10% of people get approved at reconsideration. And then if you file another appeal, that you go before an administrative law judge, that's what we've been talking a lot about, and that's frankly where we expect many, if not, most, if not, cases to go. And the approval rates nationally, what gets published is about 45% of cases get approved, but that includes a lot of dismissals and other things. If you have strong evidence and you can't work, that is your best chance of being awarded the benefits. Okay. So that's kind of the disability process. There's other reviews after that. There's the appeals council, and then you can file in federal court all the way up to the Supreme Court of the United States. But you must follow deadlines. If you get denied, don't just keep starting over. File an appeal. Understand they want you to give up. They want you to tear up that paper and say, I must not be disabled because it says I'm not disabled. That's what they want you to do.
I'm shocked at the number of people, and I shouldn't be, but who call and they're like, I was just so disheartened after I got denied the first time. And I'm like, please, please do not take this personally. This is not about you, or you didn't submit something the right way, or your application's flawed. This is an insurance program that's balancing the amount of money coming in that's going out. And it's unfortunate that it works this way, but it's not about you personally. The denial letters that we receive on behalf of our clients that you, or that all the clients also receive as well, are form letters that their names have just been substituted in, and that is what Social Security sends to everyone. So it's not a personal thing if you are denied. Do not give up, do not give up, do not give up. Yes.
And you, for pretty much every appeal, have 60 days to file that.
Yeah.
Don't miss that deadline. File the appeal, okay? The definition of disability under Social Security is different than pretty much every other program. You know, having 100% VA disability rating is not going to make you eligible for Social Security disability. You know, being able to get a discounted bus pass from your local municipality isn't evidence of you being disabled. Having a handicap placard doesn't mean that you're going to meet Social Security's standard for disability. It's just important to understand what we talked about on this first slide, which is what Social Security's definition of disability is. You must prove that there is no work at all that you can do for a period of at least 12 months, earning, you know, $1,310 a month or more. That's their definition. Private insurance companies can have their own standard, but Social Security has this one. So this is the framework that everything we've talked about today falls under. And then,
Michael, I just want to pause you for a second. Elizabeth, yes, thank you so much for your question. We did address that. I definitely want to keep moving through where we are in the presentation, but we will address your question at the end, if that's okay, because we talked about that at the very beginning. She's still working and she's waiting decompression and has to hang on for health benefits. So I definitely want to get to your question, but we did address that at the beginning. So thank you for being here. Thank you for your question. Let's keep moving through, and we will flag this one to answer at the end.
The last thing is just to understand that this is a process. You know, Jen said that cases often take 2 or 3 years. That's in most parts of the country. If you get approved at your first ALJ hearing, you know, we have I get many people approved who have been fighting the benefits without starting over, one continuous application, but I had to go to federal court 2-3 times and kept getting it sent back for new hearings. The case is 10 years old. I just recently got somebody approved who was literally one of my first clients as a lawyer. You know, I didn't have a bald spot when I started representing this.
But it's a lesson in the patience and the understanding and not giving up, you guys. That is what I tell everyone. Please do not give up. Like, stay persistent. Do not, and that is where, you know, I know that, and we'll talk about hiring an attorney at the end. There's a lot of this that you can do on your own, but if you are getting worn down and tired about it, you know, everyone who does disability law works on contingency fee. So they are not getting paid unless and until the case is won. And so don't let that shy you away from hiring an attorney, that you can't afford it, or that, you know, you're worried about costs going through the roof. It's a capped fee, and it's not paid out until the very end. And do not give up. Oh, sorry. Good segue, Michael.
You know, I want to spend most of the rest of our time answering the questions that people have, just talk about what I think is probably most important on here. You talked about how attorneys who do disability work by law work on contingency, so you don't have to be able to afford a disability attorney. They don't get paid unless and until you are approved for benefits. They'll usually help you get the medical records. I mean, Jen and I get records for all of our clients. We don't expect our clients to do that. You know, a good attorney will handle all of the communication with Social Security for their clients so that, you know, the client doesn't have to do that. And, you know, the bottom line is, in my private practice, my job is to focus on my client's case so that the client doesn't have to, so that they can just focus on their treatment and getting back to their life and how things were before disability was a necessary option for them.
One thing that I think is a really good thing, a tip, is if you haven't applied yet or if you're starting to apply, is keeping a list of your doctors kind of accessible and able to, because that is the thing that Social Security is going to want for your application and that your attorney will want, is to be able to request your medical records. So having all of that information accessible. And I know that that seems obvious, but it's really helpful just to stay organized if you keep a list of your providers, the street address of the office that they work at, their fax number. We still use fax, which is amazing to me, but we do. We use fax numbers to request medical records, and their phone number. And then we have a question: does it make sense to hire a disability attorney after you've been denied or even before you apply? I think that's a really good question. I have clients come to me at all steps of the process. I will have a client say, I have a hearing in 2 weeks. Can you be my attorney? And I have clients that have not even applied yet. They are waiting to stop working. I like taking clients really at all parts of the phase of all phases of the application process. But I will tell you, I feel like, and Michael, I actually have to credit you for teaching me this. I feel like I can help someone set themselves up for success so much more at the beginning, because I can tell them how to communicate with their doctor, and I can really, really help them create robust medical evidence. And I feel like that is what's most successful. So I have seen cases where it's like, man, I wish I would have had this 2 years ago at the beginning, because I could have helped with their, you know, medical evidence and with their paperwork. But I think it's definitely worth calling someone and asking them what you think before or after. And then if you feel like you can do it on your own and start, I think that's fine too. How do you get to a hearing? I was just denied, but everything happened on paper. So that's a great question. So it starts with the initial application. If you're denied at the initial level, you file your first appeal, which is called a request for reconsideration. Like Michael said, you've got 60 days to do so. If you are denied at reconsideration, you file another appeal. It's called request for hearing. And that is when you will be set for hearing. So it's at the second appeal where you're requesting a hearing. In Colorado right now, that's taking about 12 to 15 months. I know in Ohio, I think it's going a little bit faster. Is that still true?
Yeah, flying through cases here.
Okay. So are we at the end? Is that all of the slides, Michael?
Yeah, we're basically, I'll leave this up so that people have our contact information, and if Caitlin wants to jump back in, she can.
And just understand, you guys, this is not our law firm. This is like what Michael said. We both traveled a lot prior to quarantine. And so when we started talking over quarantine, we were like, what can we do to really help kind of right the wrongs and the misnomers? And so that's where we came up with Elevate. And it's really a way to educate groups. And we talk to groups like yours pretty often. And so we're happy to just talk you through, even if it's like any nuanced part. Please feel free to reach out. We love doing this. We love talking to people and helping. So.
Okay, so I'm gonna first of all say that the chat box is still open, which good, people are still doing it. This is a good question though. How is the contingency fee usually paid out? Does it come from the state or from the benefits themselves? Or
I can take that. So the government divides the fees at the end of the case. So you know, there's an accrual of benefits called back pay from the time somebody applies, or in an SSD case, as much as up to a year before somebody's even applied for disability. If you can prove that you were disabled during that year and meet the statutory definition for disability. But then at the end of the case, there's that lump sum. Social Security will send the fee, which is 25%, but there's a max fee for an attorney of $6,000 directly to the attorney, and the rest goes to the claimant. So, the client never has to pay the attorney directly. The attorney is never handling client funds. It's kind of nice.
It's really nice, yeah.
I'll handle this one too. Do you take clients out of state? I don't know if that's even something that's permitted right now, but maybe with COVID, the things have been relaxed.
Yeah, the good thing about actually, even prior to COVID, I was running more of a virtual law firm and was taking clients all over the nation. It's a federal program, and so if you are an attorney in one state, you actually are eligible to practice in all of them. And so we actually, Michael has clients all over the nation, and I have clients all over the nation. COVID has made that a little more accessible with the phone hearings. So that's been nice.
Used to be on airplanes, but now doing it
I know.
So I know we kind of discussed this, but a question came in earlier that this patient has Chiari 1, it causes severe headaches, double vision, numbness. Basically, they want to know, how do you know if someone is a candidate for disability? Is it purely subjective? What would you
say? Do you want me to take that, Jen?
Sure. I mean,
I don't know if it's only for me, but your camera seems frozen for me.
Mine?
Yeah. But anyway, so to answer the question, if you feel that you can't work full time because of your symptoms, it's important that you start reporting everything, hopefully even before you got to that point, you were reporting everything that was going on to your physicians. Now, the question involved the word subjective. Medical records don't come right out and say, this person has headaches that would make them unemployable. Instead, what medical records are more likely to say is this person has, 7 headache-free days per month. The nature of their headaches is that they're going to last for 3 hours at a time. When they're having headaches, they're feeling nauseous, they're vomiting, they're experiencing photophobia, so they need to be in a dark room by themselves. Here's the treatments that we've tried to assist them. Maybe they've gotten as far as trying Botox, or depending on the type of headache you have, there's very different treatments. I myself, as I mentioned at the beginning of the presentation, have what they call suicide headaches. I have cluster headaches, which are considered the worst kind of headaches you can possibly have, but thankfully they're controlled. The bottom line is it's important that you're reporting all your symptoms to your doctors. Hopefully you can get your doctor to complete one of the forms that Jen was talking about called the medical source statement, which gives your doctor an opportunity to say, based on their expertise, these are what the functional limitations would likely to be, to kind of link the medical records to a vocational opinion. And then it kind of, that's how we form our arguments for why our clients are unable to work.
Do you want to add anything, or?
Yeah, the one thing that I wanted to add to that is if you are experiencing headaches like that, you can start keeping a headache calendar. I know for clients who have, IBS or other fatigue issues, those types of things, I say, print out a calendar. My office could send a calendar, basically charting every single day. That's another piece of medical evidence that you can submit. You can write the numbers of each calendar date down and just check it off if you had a headache, or put a check mark for each headache. So
a follow-up was, where can you get these forms? So is it something that your offices would be able to provide? I think there are apps. I'm not sure.
Yeah, so, we've built out medical source statements for pretty much every type of impairment that you can think of. I actually don't know that I've ever seen one for like Chiari, for example. I would love to build one that I give to you guys that you can, put on your
Yeah,
website so that people can
let's
download.
do that.
Yeah, we'll do that. We'll start working on that right
Do
away.
you have a resources page, Caitlin, that you guys could just put it on there to download, or?
Yes, we do. And I
Okay.
might actually make a separate section where we also include this video so that people can have everything available.
Sure. Okay.
I want to ask this one question before I get to one of the questions that came up in the chat, because it's still kind of on the I haven't had disability yet. So essentially this patient received treatment for Chiari and Syringomyelia. So they underwent decompressant surgery a couple of years ago in 2018. Does that surgery negate their eligibility for disability going forward? So they were treated for the condition. Can they still get disability?
I saw that question, and I'm glad you asked it because I wanted to address it. The question is always going to be about what are the functional limitations that remain. If you had the surgery and the surgery cleared up all the symptoms and the person was able to go back to living their normal, healthy life, then they're not disabled. And, hopefully they can go back to working full time. However, if they continue to have symptoms that would keep them from being able to work full time and or working at a level of substantial gainful activity, then yes, they would continue to be eligible for disability. So a surgery itself, no matter what your condition is, so having nothing to do with just these conditions, is not going to make somebody ineligible for benefits. The question is going to be, how much functioning do you get back? A lot of times people get none of their functioning back. Maybe a surgery is recommended, and a lot of times it's not even a for sure thing that Chiari was what was causing the symptoms that were there, so the surgery is unsuccessful. It's a sad, but that happens. It's sad when that happens, but it does happen.
This is a question that came in earlier as well, but it's in the chat as well. This person was on disability several years ago. They received a letter that the 93 months of Medicare is about to expire. The questions were that the form letter, I assume that they sent, the date is incorrect, and it wouldn't be the full 93 months. And is the SGA figured into obtaining extended Medicare benefits? I guess we'll take one at a time. So is SGA figured into obtaining extended Medicare benefits at all?
Well, once you're talking about extended Medicare, you've already exceeded SGA and they've terminated you from disability. So we're beyond talking about SGA anymore. So let me start by answering that. And then what are the other pieces to the question?
So the other thing is, on the form, it appears that the date is incorrect. So is that something that you've ever seen happen where the paperwork is kind of
There's human and computer error all over Social Security forms. I remember I was just telling Jen about a funny situation where I got a call from Social Security asking me to amend to a wrong onset date in a disability case because the judge wasn't paying attention to the record. There's just so many problems like that come up. If it's something that's going to negatively impact you, I would just call the Social Security office and bring it to their attention. I think that when I did see this question beforehand, and I think it said that you'd spent hours and hours on the phone with them already. The problem is, here's another Michael one-liner. If you call 6 people at Social Security, you're going to get 8 answers.
Yeah.
So,
Trying.
you can keep trying and trying and trying. You can't just look for an answer. You just got to get a result.
Mm-hmm.
And what I always do is ask to speak to a supervisor. And if I don't like what that person says, let me speak to your supervisor. If I don't like that person says, give me your director or your supervisor, and just work your way up the chain.
Yeah.
Is that a situation where maybe the legal counsel might be a little bit helpful? I don't know.
Probably not. But what could be helpful is contacting your congressman or senator.
That's a really good point. Yeah.
because getting
Yeah.
them involved is oftentimes useful.
Yeah.
It's something that we do a lot of times in the office. Something that I did very early in my career that's paid off a lot for my clients is just befriending the local politicians. I don't care if they're Republicans or they're Democrats. This has nothing to do with my political beliefs. It's that they can help my clients and they can move, when they're struggling, they can get them answers on their cases. They can sort out these nuanced issues, because a letter to a local Social Security office from, Senator Sherrod Brown of Ohio means something. So going to your local politicians, I mean, that's like a national politician, but that's who you should be going to. We're at the federal level here, can really be helpful.
Yeah.
Yeah, that's really important. I know a lot of people don't think of that, but they're there to help you at the end of the day. So a question came in. There's the patient who's determined permanently disabled by long-term disability insurance company. But she's having she or he, I'm not sure, is having a hard time identifying a clinician to help fill out their forms. So essentially, her Chiari specialist retired, and the surgeon who placed a shunt was told that he can no longer do certain surgeries like that, and they can't get an email back. So who, I guess, is the clinician that should be charged with forms going forward? How do you find that?
Any treating physician can complete paperwork. If it's a doctor that you've seen more than once and they're going to offer a helpful opinion, I'd get it.
Yeah.
I will say that there is a such thing as having too many opinions in a file, and something that, Jen and I don't even really talk about that much, but I have seen it be a problem in a case where somebody comes into my office with 6 different opinions from doctors, but they all say different things.
Yeah.
And then, a judge goes, this seems like it doesn't seem very credible to me.
Right.
So,
it'll be unpersuasive, but I think too, in that scenario, I'm wondering if a doctor could even look at the other medical records of the other patient. I mean, certainly forms, I always ask, what are your 1 to 2, 2 to 3, doctors that are your most, like your biggest advocates, that you have the best patient relationships with, that have known you the longest. Certainly, if I see that somebody's only seen them 1 time, it's going to be a different opinion than somebody who's been treating them for 3 years. But other doctors might be able to look at medical evidence and then from there give an opinion. And they could just write a narrative letter that says, I've reviewed this evidence. This is my opinion on this. That happens a lot. That's the other thing. If there is not a form that you can find, there are narrative letters that doctors can write that just talks about how long have you been treating, what are the diagnosis, what are the symptoms that come out of this, and how would that affect someone's ability to work. If the doctor can answer those 4 things in a narrative letter, that can be powerful evidence as well.
So to get to the question that came in the chat that was sort of addressed already, I actually want to add a caveat to it. So this individual is waiting for surgery. They're currently employed, but they can't work right now because of all that. And I guess my question is twofold to add on to theirs. One, how long does it take to receive those disability benefits? And then B, can they be applied retroactively in the future?
So, Michael, just to clarify more, so she's currently employed and she's has to hang on for the health benefits. Okay, she's out of FMLA, and the employer denied all reasonable accommodation requests. So,
it's not even if you are employed, but if you are not working currently, then you are not earning money.
But I think she is currently employed. So
question, sorry.
It would be after you are not employed. What I'm hearing is that she's out of options as soon as she's not working anymore, but she has to hang on for the surgery because that's where her health insurance is coming from. And so what my advice would be, and I'm not sure if, I mean, Michael, correct me if I'm wrong, but it would be that you would apply when you stop working.
Yeah.
And the reason is if you don't, you'd get a technical denial. And so that's just the problem there. But let me make sure. Yeah, if you're currently employed, you're just not going to be eligible. But at the day that you're not employed, that's when I would file for Social Security. The thing about it is they can be applied retroactively as long as you're still eligible. So say that you waited a year to apply, you're not employed anymore, you have to give an onset date. So what date you believe that you became disabled. And so then at that point, the benefits, if the judge agrees and your medical evidence supports it, then your benefits can actually be retroactively applied back to that onset date. So hopefully that answers the question that you were asking, I think. Yes, Corey, I can restate the 4 things. So in a narrative, and we can also send this out. We can add that slide as a narrative letter. But what you would want is how long the doctor has been treating you, the diagnosis that the doctor has given you, the symptoms that come out of those diagnoses, and then how that's limiting you from working and functioning. We can, I made a note, let's add that slide actually to this presentation, and then we'll throw it over to you guys.
I'll read this one. So it's just that they're in a pickle because of the FMLA. It's not till August. Thank you for taking the time to help, though.
Got it.
I guess if anyone has any other questions, I guess we'll do a quick last call. I just have a question as far as timelines go. So from, say, your first submission to disability, about how long does it usually take? And I know you were saying there's kind of changes depending on where you're living. But what's the average, I guess, nationally that people can expect?
Probably about 2 years from application to hearing.
I would say 18 months to 2 years. I mean, the kicker is once we get to a request for hearing, once we do a hearing, they vacillate from 30 days to get an opinion to, I mean, I have one coming out of Arizona that I did the hearing definitely in the fall of 2020, and I still haven't gotten a decision. So, yeah, unfortunately, it is a long process that you have to just settle in for.
Yeah.
Are there specific? Oh, go ahead.
No, I mean, I was going to say that the 2 years sounds like a really long time, but what you have to understand is Social Security thinks they're doing an amazing job. And relative to what I've seen, they are, because when I started practicing, the average case took about 4 years. So
Yeah.
they've got it down by about half.
Yeah.
Are there specific, I know it's 60 days after the first denial. Are there other deadlines that people should be aware of, I guess, at the onset when they're starting to apply?
Yeah, the 60-day. Yeah.
The paperwork that they send has paperwork, it has deadlines. Like when they send you, so when we talk about the deadlines, I think what we addressed before was, how long you have to file the appeals, but you also want to be cognizant of deadlines like, you're dealing with the adjudicator who sends you the function report and the work history report, and they're probably going to say to you, now we need this back in 2 weeks. Make sure you get it back to them, because you don't want them to send you a denial that just says you weren't cooperative with us.
Right.
If you do get a denial, I guess how many times are you permitted to apply or give a bunch of denials? Appeals. How many times are you allowed to do that? Is there a finite number? No. Great.
And you can appeal these cases all the way. You can appeal one application all the way up to the Supreme Court of the United States. It's very rare, but there are Every year there's it's not an individual necessarily applying for disability. It's usually a specific issue inside of a case that gets taken all the way up to the Supreme Court, as opposed to this person believes they're disabled and was denied. However, cases do get appealed up to the Supreme Court. And, but, you know, you can, if you do start over, you can keep applying and applying and applying and applying. We think you should appeal. You should appeal and not just keep starting over.
Yeah. You had mentioned earlier, Jennifer, that a consultative examination is a possibility. So if that does happen, does the judge tell you which physician you should see, or do you see your own physician for that exam? Like, how does that work?
So it's going to be ordered by Social Security, and it's not going to be a judge. It's going to be DDS. So it's actually going to be the state agency that assigns you. And those actually, it was really interesting during COVID. Those obviously were affected because you know, for a period of time, they could not do a physical examination in the office. That, I think, in most states has actually changed, and now they're allowing CEs, but it was recent that they allowed that, Michael, wouldn't you say? Late fall. So yes, but it'll be ordered by DDS, and it'll be basically just sometimes they'll give a courtesy call for some of my clients, but other times they'll just send a letter that states the date, the time, the facility, and then you have to send confirmation. So.
And so,
yeah.
But essentially they select the physician that'll be doing it. Okay.
Yep, it is paid by Social Security, and that is the person, which is why it's even more important to have your own evidence in there from the doctor that knows you and has seen you so many times, because that can combat any negative findings that a CE might produce. So, yeah.
And then I think this is a really good question to end on, because it kind of comes back to the services that you guys provide. So what are the options for people who are trying to go through this ridiculously complicated process that we've just spent an hour and a half talking about, for people who have limited financial support? So they're obviously already struggling, they need the disability benefits. What can people do? Do they reach out to you, and how do they do that? Or what happens next?
Michael, you take this one.
Oh, I always say call Jen, don't call me. Call her. He's the far superior lawyer of the two.
I think that's not true at all, obviously. I think that each state is different. There are different resources. I do want to highlight something that I think Michael's office that I just love. So can I just brag a little bit about kind of what you've done and implemented? He has actually created, I love this, like an employee who is completely dedicated to finding what I would probably describe wraparound services. So other services that people who are in need, and this person actually calls each one of his clients and kind of talks to them about what they need and who they can connect them with, whether that be food stamps or housing, or, I mean, it's a huge array of things. And so it's more of like a full service law firm. This is a service that he's providing for free, but that's rare that law firms actually provide that. That's why I think it's so special that he's doing that and really serving his clients in that way. I think that other state agencies kind of have other services that you can find online and Google those things. But yes, there are resources, but they're limited, and you have to really, really know how to work the system and be pretty savvy and don't give up. Just keep going after anything and everything that you can. But it's hard. A lot of my clients they don't feel well. You know, they're financially stressed, and they're navigating through a process. It's very, very difficult for a lot of people.
That just so thank you for that. First of all, that made my inner public health nerd very, very happy, because that's
I know
that's social determinants of health and everything. So that's huge. And I guess I'll add that when we're talking about politicians and local representatives, if you go to the state and the municipal level, a lot of those resources are also available there. But I just want to thank you both so much for this really great talk. It was informative for me because I didn't know half of this, frankly.
Thank you.
So
I'm
yeah.
really glad. And if you guys have any other feedback for us or any other questions, like we really are here to serve. We really do want to help. It doesn't stop here. So I know we're, capped on time tonight, but please feel free to reach out. And if we want to come back and do like, a second edition of this, we're happy to address that as well.
Yeah, and so someone says, thank you so much for this webinar. I have a direction and an aim now. So that's
awesome.
really great. Thank you. And
Very good.
We're going to be in touch definitely about maybe getting together a form specific for Chiari and Syringomyelia and stuff like that, because obviously it's a really important thing to get done.
We would love to help you with that. That would be wonderful. I think it's helpful.
Thank you both so much.
Thank you. Thank you, everyone. Thanks so much for your attention and listening. Bye. Stay safe.
Bye. Thank you.